Everyone. This is one of my favorite groups because we need both a national approach and a multidisciplinary approach for the protection of children. It's just not enough for the individual practitioners, the lawyers, and everybody else not to talk to each other because it's all interrelated. And so what I'm going to focus on today is the legal side and why we're at risk for having our children in situations where they shouldn't be in the faith context. Faith is its own kind of universe, as you well know, and so there are special concerns. But let's face it, children get abused, neglected, abandoned in many situations in the culture. So a lot of these principles will apply to everybody, but let me start with the dangers to children just in the religious scenarios. So the first thing that concerns me about religious organizations and children is inadequate education. And in Wisconsin v. Yoder in 1972, the Supreme Court recognized the right of the Amish to take their children out of school in 8th grade. The court wrote an opinion which was basically a love letter to the Amish, saying that they had never had any legal problems, that they were upstanding members of the community, and if you've seen Witness, you know it's all true, right? What happens, though, is if you, as a young teenager or adult, decides not to be part of the Amish culture, if you make your own choice about your faith, you are now without even a high school degree. You can't do anything without a high school degree. And so many of these children are literally abandoned because the rule among the Amish is that you are shunned if you leave the community in the first place. You're already cut off by your family, but you also don't have the resources. And so the inadequate education literally has trapped the child from early on, and it's my view that Wisconsin v. Yoder is the most incorrectly decided decision by the Supreme Court regarding religion. I think it is wrong on all counts and doesn't fit in with the others, to speak in Sesame Street style. But the other issue that comes up in the educational context is that the Orthodox Jews and the ultra-Orthodox Jews have been routinely educating their children at yeshivas, which teach Hebrew, Talmud, and Yiddish. But they don't do anything else. It is very sad that we have very smart children that at the age of 18 cannot read, literally, definitely can't do math, and have no idea what science is. What that means is that child is trapped because they can't maneuver the outside world, and again, the organization will essentially discard the child that's rebellious or wants to be educated, and I don't know why the copyright symbol's in the middle, but go for it. So this is the second example of how children are disabled in their future through the approach taken, and then the legal system has essentially ignored the private religious schools. They do not check on them adequately. They do not force them to measure up to the state requirements. It's the usual and the biggest problem we have in the United States for children. We have this hands-off approach. We'll let the people who we can trust take care of them, and then it turns out it's really not good for the children. It's awesome for the adults in their system. But then we also have the FLDS, the fundamentalist Mormons. Now, the fundamentalist Mormons are the best example, although there are many groups like this, where you have extreme insularity, you have inadequate education because they routinely do not educate their children. Instead, they work in the fields or they work in the factories. The FLDS has the only contract with the Department of Defense for a particular widget and many logging facilities. And children work with heavy machinery on a routine basis and are injured, but nothing happens. And I'll explain a little bit later how it's even worse than it sounds. So, but then, as you all are very familiar with, of course, we have medical neglect, which these are the three most problematic groups, in my view, in the country right now, with Followers of Christ taking the lead. Followers of Christ is the group up in Oregon that it was found that they had a cemetery of children, and it was far too many children for normal statistical analysis. And it turned out that they had a very large number of children after their bodies were exhumed that all died of treatable medical ailments. The Followers of Christ do not provide any medical care, and they hide from the authorities so the authorities can't intercede. Now, Oregon strengthens its laws a little bit because there's a law in most states against medical neglect, although a number of states have exemptions for faith healers. Now, one question that you have to ask yourself is, why would there be an exemption for anybody involving the medical neglect of children? Why would you let people put children at risk? That's not just educational disability, that's death, permanent disability. Dying of diabetes is a horrible disease, and it happens all over the United States on a routine basis. Well, it's all politics. During the Nixon administration, there were two members high up in the administration you might have heard of before, Ehrlichman and Haldeman, partly involved in Watergate, and they were affiliated with the Church of Christ Scientists. They were Christian Scientists. When the bill was prepared to institute payment to the states for medical funds, they added a proviso that said the state does not get the medical funds unless the state enacts an exemption for faith healers. So you could only get the federal money if you gave the faith healers the right to be able not to provide medical treatment. Now, most people weren't paying any attention. In that era, hardly anybody knew anybody was really letting kids die, just for faith, not due to, untreatable ailments. But once this became known, and actually a woman by the name of Rita Swan was one of the first voices, and Rita basically takes the position that she messed up her life by letting her child die at 5 of meningitis, and that she does not want to let anybody else do that. And she's kind of living a life of advocacy and penance in order to try to protect children from medical problems with her group, Children's Healthcare is a Legal Duty, CHILD. I really want to know how long it took them to figure out the words to make child out of what she was trying to do. I'm impressed. But anyway, so we only have medical neglect exemptions solely because the federal government created it as a requirement for the receipt of money. Then groups started to figure out and started to lobby. Of course, children don't vote, so nobody cares, but some of these groups did make some inroads. And so the medical neglect exemptions have been shoved back in some states, but not in every state. But in Oregon, after it was revealed that the Followers of Christ had let so many children die with just lacking simple treatment, Oregon strengthened its laws and did start to prosecute. And so they moved over to South Dakota. They've been in South Dakota about a year or two. And during that period, over a dozen children have died of easily treatable ailments. And just to give you a flavor of the political legal side of this, so many advocates, including myself, spoke to the South Dakota legislators and said, you must not have a medical neglect exemption, or you're asking the followers of Christ to set up all of their people here and let their children die, and it's on your hands. And it was on the fast track to eliminate the faith healing medical exemption. And however, the Republicans decided that this was a disastrous thing for religion, that you had to let religious parents make the decisions about their children that they would, and they killed the legislation. So the followers of Christ are in South Dakota, and they are going to stay there until anything happens. We'll see if anything else happens. Jehovah's Witnesses, of course, have it just, the specific blood transfusion. So the most at-risk children for Jehovah's Witnesses would be kids with leukemia. Okay, so the huge part of this is, for me, is the suffering of these children. It's not just that they don't get medical treatment and then they pass away into that great beyond, right? They don't get medical treatment and they die and they suffer on the meantime. Now, what I want you to think about is these kids are trying to survive with the medical treatment, right? These children are in a hospital and they have better odds of surviving leukemia and all of the problems that afflict mankind. But think of a child who has, the one on the left is leukemia, the one on the right is diabetes, who's sitting on their parents' couch and the treatment is a prayer. For the diabetic, it's horrific inability to get over this feeling and sensation of being dehydrated. And they become extremely thirsty, and they also become disoriented and eventually die, but it can take several weeks. So medical neglect is part of the larger picture of how faith groups can put children at serious risk. But the other issue we have, of course, is polygamy and child brides. Nobody knows that more than Texas. Which you got to hand it to Texas. I was born in Dallas, so I'm going to hand it to Texas. This is, of course, Warren Jeffs, fundamentalist Mormons, and this is the picture he proudly put up online when he married this 13-year-old. And he was responsible for setting up the Yearning for Zion Ranch in El Paso and then choosing who would be placed on the ranch. You had to be a very special spirit to be placed on the ranch. He split up families, he split up couples, he split up committees, right? So it's always one man and 10 or 15 or 20 wives. And he would choose which children would go. And he would break up the biological mother from the biological child. And so Yearning for Zion was all people who had been yanked out of their homes, but they were in a special place. This was going to be very special. What the numbers with polygamy drive everything and lead almost inevitably to the abuses that we see in the fundamentalist Mormons, but also that we see in, there's a large number of polygamy groups in the country, both Christian and related to the Latter-day Saints. So here's how it happens. On average, females and males are born in about the same numbers, right? And so, but you have a system that needs one male to 5, 10, 15, 20 women. And in order to do that, you must discard some of the boys. There's just no other way to deal with it. And so what you do is, if you're in the FLDS, is that you drive them to Phoenix or Salt Lake City. You drop them off at a corner, you say, we will never talk to you again. If you try to contact us, we'll kill you. With no money, no means of survival, and the vast majority, originally, for many years, had nothing but prostitution to turn to and ended up being drug addicts. That's changed somewhat because there are two wonderful groups in Salt Lake City that have created a Lost Boys Foundation. And again, it's just good people doing good things for children. They search for them. They try to get to them before they've fallen into the worst of the criminal side of the culture. And they bring them into houses. They get them educated with a high school degree. They try to help them get into college. They try to teach them trades. They do everything they possibly can. But these are people, young men, who have never worn anything but the uniform of the FLDS. They've never eaten anything except what is provided by the prophets. And in addition, the children are given vitamins, which needs to be investigated. Here's a family portrait of one man's family. So if you are going to have, this is your goal, this is one of the leaders, Joe Jessup's. If this is going to be your goal, you have to get rid of some of the boys. But for each man, as he gets older, he has to go to younger and younger cohorts, right? Because when he was born, it was even. Then you got rid of some of the boys, you discarded them. But now you have fewer possibilities per man. If your goal is 10, and that's, small. If your goal is 10, you might take one from your age, then one 2 years younger, the one 4 years younger, and when it finally works out under Warren Jeffs, you look for the girls that have just become fertile. And the minute that they can have a child, you impregnate them, and that's the result of it. Now, there are other cultures that practice polygamy. There is a Christian pro-polygamy movement, the leader of which does email me routinely to make sure I know how great polygamy is. And there are other polygamous cultures, including the Muslims, who have been very forceful up in Canada trying to get rights, but also worldwide. Now, for most Muslims, the belief is that you have to support the wife and that your maximum is 4. That's not enforced everywhere. But so these numbers aren't as extreme. So the one man is not taking, Joe has 20 wives. The one man is not taking 20 wives. He's not imposing on the culture this many children. And by the way, how do they support these children? Welfare, thank you. Yeah, welfare fraud is how they support them. The man says legally the first wife is his wife, and all the other wives are required to apply for welfare for them and for their single mother and the children. And then, of course, the check must be handed to the husband as soon as it's received. She is not allowed to touch the money. So let's move on to sexual abuse. The truth is that clergy sexual abuse is in every single denomination. There was a time when I started working in this field where it really did look like that the Presbyterians, which is my own faith, had basically locked up the right to say they'd set the gold standard. They didn't have the problems, blah, blah, blah. And I just did a very small amount of digging, and it turned out that they had a missionary they knew about in Africa who had 49 child victims in a very short period of time. So they're in there. So the point here is that it's not the Catholic Church. The reason you hear so much about the Catholic Church is because it's the biggest, largest religious organization in the world. It has billions of members. And because of the internet, we now have a worldwide conversation about this, and we have all these people coming out. What you see in any sexual abuse scenario against a powerful person, whether it is a priest, a rabbi, or Bill Cosby, is the first victim comes forward for that perpetrator, and it empowers the rest of them. Right? It's very rare that a child predator is going to stop with one victim. It's extremely rare. And so what normally happens is you'll have a particular faith, one victim comes forward against one perpetrator, but then there are rumblings. And what happens is that the survivors get survivor's guilt, especially if the victim that comes forward was raped before they were. And then they feel like, if I had reported him right after this happened to me, he wouldn't have done this to all these other people. I say he because it's about 95% of child abusers are men, but they're not all men. About 5% are, in fact, women. 1 in 4 girls across the culture, religious and non-religious, are sexually abused. About 25%, 1 in 6 boys are sexually abused. So what do we do about clergy sex abuse? What used to happen in the legal universe is that someone, a parent, would report abuse by a priest to the district attorney in Philadelphia, let's say. And the bishop would immediately call, or the DA would call and provide a favor to the bishop, and say to the bishop, look, you've got a problem. You've got a problem. And the bishop then would promise, okay, no problem. I will take care of it. Just don't put our dirty laundry out in public. And because prosecutors did not understand it was a system, not just one off here, one off there, they would say, sure, I trust you to go take care of your problems. I've got the mafia. I've got other issues. And so what that permitted is for the institutions to fly under the radar, right? And they could fly under the radar because there was nothing public, and the prosecutors were not gathering the evidence adverse to the religious groups. That happened constantly. But the second offender, in my view, in the story of clergy sex abuse, is that the newspapers, the media, would not cover the issue. The Boston Globe broke the story. There's now going to be a feature movie, blah, blah, blah. But 2 years before that, a woman by the name of Maria Rode, up at the Milwaukee Journal-Sentinel, had broken the story about abuse in the Milwaukee diocese. But to her editors responded by saying, delete the story, and you are now on the local beat. You're no longer a religion writer. That happened across the country. There was 2 reporters in Philadelphia Inquirer who were fired for suggesting the story. And it really took a lot of guts for the Boston Globe to do it. But I'm not going to put them up on too high of a pedestal because they knew about it for 2 years. They had 2 perpetrators, Shanley, who was a member of the National Association of Man-Boy Love, and then we all had Gagan, hundreds of children abused by a man into his 70s. So during that 2-year period between their debating whether or not they can actually publish a story and survive because the bishops will shut them down, there were children being sexually abused. And nobody was helping them. So that should give you a sense of the protection, how hard it is to protect children in our culture. It's just very, very difficult. But it's getting easier. Why? Because we have so many more being empowered to say it, to come out and to say it's not my fault, it's his fault. I'm basically dyslexic, so I'm capable of doing this upside down. We have 2 kinds of defenses to these kinds of claims that churches can raise. And we have both the constitutional defense of the First Amendment, but we also have state statutes. And I've already mentioned the medical neglect statutes, which are very specific. We also had state statutes, for example, that exempted clergy from reporting child sex abuse. So all professionals would be required in the state to report sex abuse except clergy. So there are all sorts of statutes. There are thousands of statutes providing for exemptions of a lot of different types. But the First Amendment says, Congress shall make no law respecting an establishment or prohibiting the free exercise thereof. Now, prohibiting the free exercise, that doesn't mean that there's 100% right to do whatever you want in the name of religion. The Supreme Court had put together a standard that was working extremely well for the protection of minorities, children, health, safety. And so for the court, they basically said, look, if this is a law that applies to everybody, the fact you're religious does not give you a constitutional right to disobey the law. But if the law is discriminatory, then the government's got a lot of explaining to do. This was in place for decades, if not 2 centuries, and had gotten us to a balance which said that religious believers and institutions are accountable to the common good, but they can't be discriminated against. You can't persecute them. And that was actually the balance the Supreme Court has held on to. That is still the First Amendment balance, but the First Amendment doesn't matter anymore, as I'll explain in a minute. Now, under the First Amendment, the religious groups have a doctrine. They call it a doctrine. It's not. It doesn't exist. They wish it existed, but they argue it in every single case. The doctrine is what they call church autonomy. And their theory is that the First Amendment immunizes them from all legal obligations, all, including discovery in all cases, including cooperating, including the right to have all of your court records sealed because it's a religious group rather than a daycare center, right? So they call it church autonomy. This was crafted by the Latter-day Saints and the Catholics, and they often litigate together. Both bishops from both religious faiths lobby together, and they also enter into largely state Supreme Court and national federal Supreme Court cases in which they constantly talk about church autonomy. But it does not exist. The Supreme Court has never used autonomy to describe religious liberty. In the United States, no one has autonomy. We all have a mix of rights and obligations to the common good. And autonomy is actually anarchy. That's what autonomy is. But religious groups now believe, in many places, sadly, that they do have autonomy, because they've been told by so many that, oh, yes, you have a constitutional right to autonomy, even though Supreme Court has never used the term, and in the last 2 cases in which the court was asked to use the term, I wrote an amicus brief in each case, and I said, you have never done it, don't fall into this trap now, and they didn't, which, that's one highlight. So in 1993, and I can't start this without mentioning that one of the best lawyers I ever worked with in killing, we thought, what is RFRA, the Religious Freedom Restoration Act, and that's Lowell Denton. Lowell, stand up. Lowell Denton, one of my favorite lawyers, and good people. It was really an honor and such fun to work with him. Yeah, on this case. So this was a righteous case. It was a great case because the federal government had been persuaded that the Supreme Court had abandoned religious liberty when it had just reiterated the standard that had been in place for decades. And so, you hand a bill with the name of Religious Freedom Restoration Act to a member of Congress, they're like, wow, I can be the savior himself. And so RFRA was popular because nobody understood it. And people on the Hill believed law professors who were literally lying for purposes of increasing religious liberty. They had never liked what the Supreme Court had said. They had been battling it for years. They had been throwing all sorts of theories out, including their autonomy theory. And the court had just stayed on this path. There's a middle ground. And so this was their opportunity. They did not like the peyote case in 1990, which was decided the year that I was clerking for Justice O'Connor. None of us thought that case meant anything. Nothing. No clerk was like, oh, I've got to do that because I'll be in history. Most important case of the term because it engendered Religious Freedom Restoration Act. So what this act says, most importantly, is that for the government to defend itself with respect to any law in the state or federal government, this would be the federal government, any law in the country that would be applied to a believer, the government must prove that it has a compelling interest. That's hard. That's the highest level duty put on the government to defend itself. But that wasn't enough. Right. The other thing the Supreme Court has never embraced and has repeatedly said no to is the least restrictive means test. So basically what RFRA did is it flipped the power between believers and the laws that apply to everybody else. And it said that unless a law is extremely important, almost necessary, and unless that law is tailor-made to this believer, it fails. This believer can break the law. And if any of you were following the Hobby Lobby decision last year, the RFRA decision, that's what happened. It's least restrictive means. The notion that the government must prove there is no other way to be able to enforce what we want to enforce, therefore the believer gets to do whatever they want. So now when all of this was going on, everybody in the country, except some of us who are really annoying, basically said, yippee, more religious liberty, because religious liberty is always good, right? But here are the misrepresentations that have been used to this day. Now, RFRAs we now have a federal RFRA applied to federal law because Lowell and I actually killed all of RFRA, but then Congress went back and reenacted it to say it was only applied to federal law. So now it's only applied to federal law for the federal one, but it's also been passed in numerous states. We're up to 20. I'm expecting Michigan to make it 21 soon. So here is the game that's being played, and until groups like this understand the lingo, they're not going to be able to fight the harm that's raised when a faith-healing parent is being prosecuted for the death of their child, and they raise RFRA, and the lesser restrictive means for them is not to be sent to jail. They'll pay a little bit of a fine, right? So radically reducing the penalty to accommodate the faith-healing parent. So here we have it, RFRA misrepresentations. It is said constantly, and the news media, this has become like one of my, well, many crusades, but a small crusade, right? Even the press still says this. USA Today said this the day after Hobby Lobby came down. I called the editor. I said, really? Who do you have on this? He didn't hang up on me, though. So federal RFRA was passed unanimously. That is a lie. It was never, ever passed unanimously. It was passed by a procedure that Congress has concocted called unanimous consent. This is what they do when they want to get bills through and they don't want to be held accountable. Here's how unanimous consent works. Leadership decides they want a bill passed. You suspend the rules. They go into session. No quorum is required, let alone a majority. And you don't need or ever have a roll call vote. So you could have a bill that's passed by 4 members in each house, which is exactly how the RFRA in 2000 was passed, but it's unanimous consent, and so you can say it was passed unanimously. But in 2000, the bill was passed in the following way. Children's groups, National League of Cities, the attorneys general, the governors, the mayors, endless numbers of groups for children, women's rights, and gay rights, all lobbied and said, you can't reenact RFRA. We now see what a dangerous bill this is, and we now know the original modus operandi. What was the initial motive for RFRA. It was the Christian Legal Society's desire to be able to discriminate in apartment housing against single mothers, unmarried couples, and gay couples. So that had come out because someone accidentally emailed me something I wasn't supposed to see, and I didn't honor the confidentiality. So federal RFRA was passed unanimously. That's not true. In 2000, we are told the morning of July 27th, 2000, that the bill has so much opposition, they're going to give us opposition hearings. That is a huge breakthrough, because so far, for the first RFRA and for this RFRA, the only people who ever spoke to the members of Congress were the faithful saying, you know, we'll never hurt anybody. This is just liberty. And so it's the morning of the July 27, 2000. They say, start putting together your panels for September hearings. They were going into summer recess that evening, okay? So they're going to go into summer recess. When summer recess is called, RFRA is brought up in the Senate with 4 people there, with a courier waiting in case anybody learned what was going on. They suspend the rules, they pass by unanimous consent, no quorum, no roll call. The courier runs it over to the House. It is passed in the House. Now, by that time, every opposition member, of which there were many by this time, had left town. Not only did they think that they were getting hearings in the fall and didn't need to worry about it, they had no idea the bill was coming up. So it was not passed unanimously. It doesn't have the force of a law that is passed unanimously. That's a rhetorical support for the law. The next thing is argued is that RFRA is safe because it just replicates prior law. As I've explained already, RFRAs are much more extreme than prior law, and this makes legislators comfortable, but it's just false. It doesn't replicate prior law. It's a much different level. And finally, and third, no worries, because believers never harm others. And I just say, read Janet's work if you want to know whether faith can be dangerous. And finally, bad cases, ones where child sex abuse, child neglect, any case involving a child. The answer was bad cases will win under RFRA because the law will serve a compelling interest. Well, yes, protection of children is always a compelling interest. It will serve that, but it's not the least restrictive means. And it's the least restrictive means that takes all of these cases down the path of harming children. So here is where we have state RFRAs at this point. Texas, the T-RFRA as they call it, the T-Rex as some of us call it, is in place. And one of the things to think about is whether or not it's possible. I know it's not possible to repeal it yet. Something will happen that will justify repeal across the country. But I know that's not going to happen yet. But one question is whether or not there are members who would take out least restrictive means. If you were to take out least restrictive means, you would give children so much more power to be protected. But that's not just true in Texas. That's true with respect to the other 20. And as I said, the Michigan will be the first in the upper Midwest. And that's largely being fueled by bakers of wedding cakes and restaurants and others who don't want to serve same-sex couples. So if you can avoid serving same-sex couples, what better but to say your faith doesn't permit you to support same-sex marriage, and if your faith doesn't do that, then you can exclude from your store all same-sex couples. You don't have to sell to them. It's a place of public accommodation, but you don't have to. The same is true for race. Same is true for women. So, the normal categories that you think of for civil rights, RFRAs are very effective against them. And in Michigan, this is all being driven by a desire to permit certain believers, and it's across the spectrum, certain believers to be able not to deal with same-sex couples or homosexuals. Florida is similar. Alabama is one of the most extreme in the country, which is shocking, I know. This is just an example. When you open the floodgates in law and you say, here's something that can be achieved by this interest, they then, once they've achieved what they're looking for to some success, they start looking for ways to inch it further out, right? So with respect to the state RFRAs, we have ordinary ones that look just like the federal one, but we have ones that are even more extreme. And at this point, the most extreme is Mississippi. It applies to private businesses. It works clearly against homosexuals and same-sex couples, and that's what motivated it. But interestingly, many business people put together a symbol that says we don't discriminate to signal where anyone who would be discriminated against, for example, a black man in a white-owned restaurant, they would know before they went in that this is a place that's going to have the capacity to shut you down or not. And so a number of businesses saw the bottom line as the more important thing than the face side of it. So who was hurt by RFRAs? These extreme religious liberty statutes: children, women, victims of discrimination of every category. If you're interested and you want to find out, well, do we even have faiths anymore that discriminate based on race? And the answer is absolutely. We have faiths that discriminate as white supremacists and black supremacists. The Southern Poverty Law Center does an amazing job of tracking them. Read that site for 5 minutes in the morning, and you'll hope to forget it by the nighttime, or you won't sleep. And apartment dwellers are the ones that suffer. So there's a lot more, but I've got limited time. So my book is out there at extreme discount, because I got my author's discount for you. And it's God versus the Gavel. This describes all of the developments, what's at stake. There's a chapter on children specifically involving medical neglect and sexual abuse. But that's not the only legal way that religious entities are making it more likely that children are harmed. One of the other tactics being taken is that the statute of limitations for child sex abuse is extremely diverse across the country. It used to be, the rule was, a child is sexually abused at age 7. If they don't get to the authorities by age 9, they're done. Nothing else they can do. A child being sexually abused by their father, their priest, their rabbi, their pastor, they're not coming forward at 9, right? They're going to need years to come forward. So the statutes of limitations, a number of us have been working on to extend for child sex abuse victims. Who is the entity that has put in millions lobbying against the extension of statutes of limitations for children? That would be the Catholic bishops. Millions. And so far, they have been successful in some states, New York in particular, but not in others. So just to give you a sense of the universe, the ideal states for child sex abuse victims in clergy settings, assuming there's no RFRA, are Delaware and Minnesota. Remarkable how much they've opened up, both forward-looking and backward-looking. California is very good. It's not perfect, but it will give the young lady, well, now she's a woman, but she was 15 when she was sexually assaulted by Cosby in California. The way the law is structured in California, she has a shot. So even though it happened 40 years ago, believe it or not. Now, the worst states in the country are Alabama, Georgia, Mississippi, Michigan, and New York. I cannot explain to you why New York is in that group. I have no answer, except the bishops. The bishops own New York City. And so the cardinal right now, Dolan, is sunk millions into making sure that children, victims, don't have access to civil justice. You'll notice that Texas is the next to worst category. Not good, sadly. And then you have others in the middle. So my goal and hope is that we will get all of the states into yellow or orange, right? I don't expect perfection in every state, but Hawaii's done a great job. Little Hawaii has done a remarkable job. Guam has done a wonderful job, but many states have not. So the statute of limitations is one of the ways that religious entities get to stay out of court. And what happens then? That means that all the information is secret. If you're not brought to court, that child does not have the capacity, if the statute of limitations has run, to give a public statement because they'll be sued for defamation by the perpetrator and by the institution. So if they're sued for defamation, they're done. So that's why victims don't speak up if the statute of limitations has run. It puts them in a very delicate position, a difficult position, and they have to pay a lawyer on a defamation claim, so they can't afford that, and so the secrets go on. So this is all about, now the Baptists have joined the Catholics in lobbying against statute of limitations reform in this state and in numerous southern states. The Orthodox Jews have joined in New York. State by state, the Lutherans tried to kill it in Minnesota. They didn't succeed. So state by state, it's usually the bishops plus whoever else is there, right? So in Utah, it's the Catholic bishops and the Mormon bishops. But that is the problem that we face in the protection of children. To protect children, we have to be able to have legal resources that will give those children, when they're adults, when they're ready, when they're capable, to be able to prosecute and to be able to sue for damages. And why do you want them to be able to sue for damages? Whether they were medically neglected or sexually abused or educational neglect, because you want to shift the cost of the bad treatment to the one who caused it, away from the victim. So on average, children who are sexually abused need about $1 million over the course of their lives in therapy. So when you hear about a settlement, this wonderful settlement that's $1.3 million in California, they're going to get $1.3 million, and they're going to need $1 million of that just to stay above water psychologically. That's not, it's not the lottery at all. And on average, the settlements across the country in a lot of these cases are about $200,000, which is not enough to get through the rest of their lives. But it means that the churches have won because they've limited their liability and also they've undermined their accountability. And the message right now to churches across the country is that what you believe in is what you do. You are not accountable to the law. You are never accountable to the law, and you're certainly not accountable to anybody involving children because we take care of children. Right? So the scenario, in my view, right now is pretty bleak, but it's better than it was 5 years ago. It's much better than it was 20 years ago. And it's because of people like you getting the message out and talking about what to do about the protection of our children that it really makes a difference. And so finally, Justice Denied is my book about statute of limitations. So it's now been provided to 10 different states. The entire legislature has received it, and we've made some real progress. So it's intended to be read in half an hour. I've been told it takes 45 minutes. But I wrote it for legislators, which means they don't read paragraphs. They read headings and table of content. And the table of contents pretty much sums it up, so that's all they need. So, but it's intended to educate the public because this is such a matter of public concern, the protection of our children, that my hope is to educate in as many ways as I can. So, thank you.
Microphone for Steve. We've got just a few minutes here.
Oh yeah, I was wordy.
Wonderful, fantastic. So, several quick things, but corporal punishment was something that was covered here, but
Yes.
you didn't mention it.
Yep.
Undue influence and trafficking, and
Yep.
because there's so many minors being.
Right. Well, the trafficking isn't really done under the name of religion as much as it's done under the name of, greed and cruelty. So, I was focusing on just the faith moments, but absolutely. Now, with respect to corporal punishment, it's so complicated state to state that I need to sit down and do my 50-state survey and figure it out. Many states now don't permit it, but some states still do. A dwindling minority, but none should. And so what I'd like to look at more is the comparison between us and the Muslim countries. I'm going to be giving a talk at Yale in November on that, on a comparative across the board between the United States and Europe on all of these issues. They are much better than us on some, and they're much worse. So, and it's worth seeing who's doing what. So.
Any other questions for Marci? Yes. Marci, this is Dave Pittman. Good
Hi.
seeing you again and all talking all that we have. To let folks know just unfortunately, how far behind we are in protecting children, can you let folks know how many states have eliminated, or I should say how few have eliminated statute of limitation laws or that have window legislation passed?
Yep. Okay, so the two options are to completely eliminate the criminal and the civil statute of limitations going forward. But that only works for abuse that happens the day that law goes into effect into the future. You may not, it's unconstitutional to revive an expired criminal statute of limitations. So the only thing that you can do for victims whose SOL has run is to revive the civil ability to sue. All right? So what that is, it's called a window. And a state will, and there's two ways to do it. A state may say, like Delaware has, Minnesota has, and Hawaii has, and California, for a certain period of time, 1 year, 2 years, 3 years, right? California was the first at 1 year. Delaware was 2 years. The most recent Minnesota is 3 years. Hawaii is now 4 years. So that's how long the window is open. When that window is open, that means that the perpetrator and the institution that supported them, whether it's a public school or any other institution, cannot plead statute of limitations as a defense. They don't have any statute of limitations defense. So the victim then has to go into court, and they get over that initial hurdle, but they still have to prove up their case. They don't have any, you can't change what they have to prove. So this opportunity to revive expired statute of limitations is out there. And as I say, those states are the only ones who've done that so far, but the bill is pending in 10 others. And we get larger numbers as we go along. So you need to eliminate going forward. Delaware and Minnesota have both done that. Illinois has done that. Florida has done that. But you also need to find a way for justice for the ones shut out now. And the only way to do that is this revival approach, basically a window. And only 5 states have done that, but it's since 2003. It is a radical proposition. And the fact we've gotten 5 states plus Guam is pretty amazing. But I can tell you, in every state where we got it, the cause was either led by a sexual abuse survivor high up in the legislature, or it was led by a mother.
Well, and that's why I think it's so important. That's why I wanted you to bring that to light, to how few, and why it's so important that all of our organizations work with, it's real simple. I'll give you SolDash-Reform.com. That's our website. It's real easy to remember, SolDash-Reform.com. You can go and find out exactly what each of your states are doing and why it's so important that we get behind the work that you're doing so that we can get it passed, so that we can protect these kids.
Yeah, thank you. I meant to mention that. So I have two websites. One is SolDash Reform.com. It tracks all 50 states on statute of limitations and has the latest news, a snapshot of every law in the country, and the silo and the graph. And then I have another website for RFRAs. It's called RFRA Perils, just so everybody knows how I feel about it. And we track all 50 states. We track news. We do it by state, but we also do federal. So I have wonderful students at Cardozo who are just amazing, put in ridiculous hours on this stuff because they're so committed, or maybe they should be committed working with me. But both of those are a daily site that you can get information about what's happening in both of those fields.
Just recently, there was a case in the States and offhand, I don't remember where, but a sexual abuse survivor went after the Watchtower Society because they hid the abuse, and she won her case.
Yes.
And got $31 million.
That was Northern California.
Okay, we need more of these cases, and there's quite a few cases coming up for ex-Jehovah's Witnesses
Yes.
now
Yes.
who are going after the Watchtower Society to nail them, and they're winning.
Well, the issue with the Watchtower Society is that the rule is that if you go outside of just the fellow believers, you are dealing with Satan. You will die. So they already have created a wall around the group. But inside the group, the rule was, they say they've changed it. I'm not sure I believe that. The rule was that 2 elders had to witness the abuse, or it literally didn't happen. Well, nobody, Now, I mean, it is true there are satanic groups, there are ritual abuse groups that do have multiple adults in a room for religious purposes and are sexually assaulting a child. But that is not the common. The common is someone takes a kid and hides, right? So that was a rule created for the purposes of keeping the secrets. They are quite unhappy right now. Now, it was 31 million. As I understand it at this point, very little's been collected.
It's in appeal, so who knows how long. The other concern I have, and I don't know if how we can stop this, but Jehovah's Witnesses are actually taking convicted sex offenders door to door in their ministry.
Yep.
And I'm right now trying to stop one guy, and it's really hard. So if anybody is from New York State, I want to talk to you.
Well, I teach in New York City.
Do you think, a number of legal scholars I've talked to think that if Wisconsin versus Yoder were to be presented to the court now, especially in terms of, breaking Amish and the things that are out in the public about that you would not have gotten, I think it was Justice Douglas who wrote that,
Yeah.
what you called a love letter.
Yeah.
Do you think that if a case were brought, even within the Amish, but on that whole issue of compulsory education, that the current Supreme Court would overturn Wisconsin versus Yoder?
Well, actually, Justice Douglas wrote a concurrence in which he said, nobody's argued that the children that want to actually be educated, right? And so, but he was suggesting maybe in the future we should, consider the children's interests, which obviously they need guardian ad litems in compulsory education. But the short answer is you couldn't have written Wisconsin v. Yoder today. You could not have written an opinion that literally has language that says that they are all law-abiding, nobody has ever violated the law, and that they are good people, right? So just think of the image of witness, the rolling hills, good people doing nice things. But the other problem, it's not just breaking Amish. It's really the stories that have come out about the most common form of abuse is sibling abuse, sibling sexual abuse. And the community protects the abusers and shoves out the girls that come forward. So, on a high note, just to let you go on a high note.
Marci, thank you. Let's put our hands together in gratitude.